I'm Julie Miller with Metropolitan Title. Welcome to Real Estate Real Connections, connecting you to all things real estate. Today we're going to be talking about the title search process with Mike Pulling from Metropolitan Title. Let's get into it. Mike, thank you so much for being here today. I wanted to bring you here because I feel like oftentimes the title insurance piece of a real estate transaction is the least understood part of the process. And so I wanted to talk mostly today about judgment searches and what kinds of things can attach to someone's real estate without them knowing. So can you tell us what exactly is a title search?
So a title search is a look back in time from the current owner backwards. And we do a search to try to find liens, judgments that are going to attach to the property from our current owner to a prior owner that may not have been cleared in another transaction.
So what kinds of things can attach to your real estate, and does someone always know if that process happens?
Well, most common that's going to attach is your mortgage as a lien to the property. After that, any judgment that you have against you can attach to your property. Liens, whether there's mechanics liens from a contractor doing repairs to your house, those can also attach to your property. Many people may not even know they have know that they have a lien or a judgment attached to their property until they go to sell their home.
So if someone has maybe gone to court, gone to collections for an unpaid bill, that can attach to someone's real estate?
They can.
Okay. Let's talk about vesting and about marital protection specifically. So can you explain what exactly is marital protection?
So a marital protection gives your property protection against judgments attaching. So if your spouse has a judgment against him or her, it will not attach to your property because you have the marital protection.
So, but if a judgment, let's say, is against husband and wife, that could attach?
That could attach.
Okay, but if it's against just one of them, it will not attach.
That's correct.
Okay, it's always a slippery slope, and I think we have a lot of questions about that. Often we see sellers who are like, oh my goodness, I did not know that I had X, Y, and Z. How do I fix this? Mm-hmm. So that's what our processors do. They work on clearing that title, maybe receiving a payoff to get those items paid through the close of escrow. How far back does a judgment search go?
10 years.
10 years. Is it always 10 years?
It's always 10 years.
Okay.
Judgments will fall off after a 10-year time period.
Okay. And what are some common issues that can arise during a title search?
Judgments, liens, encroachments on a property line, possibly, depending on, for agricultural or a meets and bounds legal description, maybe the property doesn't close and we have to require a survey to get an accurate legal description. How often would you say that's the case, or how often do we recommend someone get a survey? We try not to recommend that someone gets a survey. If we can try to figure out the call in a legal description of a meets and bounds type, then we'll insure it. But when you have a historical legal description that's been in use for 80 years, you're not going to require somebody to get a survey.
I know, being in the title industry for a long time myself, there have been so many weird things that have come up. Recently, I had an agent contact me about someone thought that their driveway was owned by them and not their neighbor who just purchased the house. And so they literally put up a fence down the middle of the driveway. And so how often do you see things like that, and how do you resolve that?
If we see something like that, usually it's a shared driveway agreement in place. If there isn't a shared driveway agreement in place, that would be a fix for a situation like that. If they're both using the same driveway and one thinks they own it and the other don't believe that their neighbor does, you could try to work it out through a shared driveway agreement.
So talking about divorce, often that's something that we see in a transaction. There's either a pending divorce or a finalized divorce. Mm-hmm. Can you talk a little bit about how a divorce affects the sale of a real estate transaction?
Sure. If we have a pending divorce and both parties are coming to closing, we don't really have any concerns. They're both coming to closing, they're agreeing on where the money's going. If the divorce is finalized, we have to go off the settlement agreement and the decree. and we have to do as it says. So if it's spouse A receives $50,000 or spouse B is quit claiming their interest to spouse A, that's what we have to follow. So it's pretty cut and dry on either side. I mean, if it's pending, we're good with both parties coming to the transaction, and if both parties are not, the divorce is probably final and we're doing a quit claim and someone's getting their check.
Okay, so since you brought up quit claim, that's often times we get questions about maybe a family member just wants to quit claim to another family member or their neighbors. Is there a time and a place for a quit claim deed, and when is it not the time or place for a quit claim deed?
There is a time and place for a quit claim deed, and that's typically adding a spouse after you've been married to a property that you already own and you want both you and your spouse to be entitled together, or in a divorce situation where now you're removing a spouse. Quit claim deeds are fine for the seller, but they're not good for the buyer because there's no warranties. So you get a quit claim deed, what the seller is giving you is here's the deed to my property and to the land and to every judgment and lien that is attached to it. It's now your problem to deal with.
So the judgments or liens against that prior owner, whether it be a mortgage or a tax lien or something like that, those don't go away with a quit claim deed.
They do not go away with a quit claim deed.
So that's why it's never a good idea for as a buyer to purchase a home with somebody quit claiming to, because you don't know what's attached to that property. And so since we were talking about divorce, let's talk about name changes and how that can affect the sale.
Sure. So if you have a name change, it's very important to let the title company know that you are formally known as and what your new last name is. Because when we do a name search for judgments, we're doing it on the name that's on the purchase agreement. So if you've changed your name, we're not searching what your new name is. And then that ends up happening at closing, and we're running a name search for judgments while someone's sitting in a closing room.
And from the closing aspect, we always have to make sure that buyers and sellers are signing with their current legal name.
Correct.
And it's illegal to sign documents with a name that's other than your current legal name. So having proper ID, valid ID, can definitely affect the closing process. If we don't have names correct, it means we're at the table and sometimes have to stop in the middle of it to either get documents corrected or to reconvene at a later time to update those things. So name changes are very important to make sure they're letting us know. And let's talk a little bit about a Medicaid search. When does the Medicaid search, first of all, why would we search for Medicaid, and what is that process?
You know, if someone is deceased and they're over the age of 55, we're going to do a Medicaid lien search, because chances are they may have been on Medicaid and we just need to verify that they were or were not, and that there are no liens from Medicaid on the property. If there is an estate open, we do not worry about doing a Medicaid lien search. That's the responsibility of the estate, and the estate will notify Medicaid that the person is deceased and check for any liens that way.
So what is the time frame involved with us having to complete a Medicaid search?
9 months from the date of death.
9 months from the date of death. And if something is showing on there, what kind of resolution do we have for that situation?
The debt needs to be paid. If it's more than the value of the home, there's not going to be any money to pay the lien, then seller or the estate needs to work with the state to try to get that down to a price that's reasonable for them.
Or otherwise it can be paid through the close of escrow as long
Correct.
as there's enough proceeds in the sale to do so.
Yes.
Okay. So Mike, do you have any advice for anyone who may be getting ready to list their home and they may question whether they have any issues on their title?
Yeah, they could speak with their listing agent, and the agent can request a preliminary title search from the title company.
Okay, and that would pull up any maybe potential red flags.
Correct.
Great. Thank you for watching Real Estate Real Connections. Remember, like, share, and subscribe for all things real estate. Until next time, stay informed, stay empowered, and stay connected.